from our perspective in terms of there's still some outstanding issues that we need to get clarification about from the officials, and hopefully get the officials to publish some guidance on some of these things as well. And now, of course, I can't get, there we go. So like I said, what we'll cover a bit of background and overview, issues specific to charities and nonprofits, and some of the things to keep in mind preparing for this. Different provisions come in at different points, but July 1st, 2014 is the one of the dates, and then the July 1st, 2017 will be the other date to keep in mind. But we'll get to what those mean in a few slides. So what is the law? You'll see it's got a about a 100-word long name, but unofficially it's called Canada's Anti-Spam Law, or CASL. So that's the short form that we've been using. That's the short form that the government's been using. And what does it do? It regulates a broad range of activities. The main one that we're concerned with is the way that it regulates unsolicited electronic messages, and specifically commercial electronic messages. And this could be emails, this could be texts, this could be instant messaging, so the various ways that you might be using to reach out to people. It also brings in new rules, new regulations, new penalties with regard to hacking, malware, spyware, phishing, privacy invasions, so people installing keyloggers or whatever, and then as well email address harvesting, which is collecting people's addresses without their consent. If you've got one of those spider programs that goes around the internet and just harvesting addresses. So basically the first one of those is really the one that is relevant to our sector. There is a Government of Canada website, the title fightspam.gc.ca. There's background information there. There's copies of the law, copies of the regulations. They've started to do some FAQs. There's also contact information there, and it's both for people to file complaints, but also as well so that you can contact them as people who are wanting to stay on the right side of the rules. Contact them to try to get some clarification if you've got specific questions about a scenario that you want to run past them. Now, there are a number of fundamental principles incorporated in the bill and in the regulations. The first one being that the activities that are set out in it, the activities that they're regulating, can only be carried out with what they call explicit consent, which essentially means, according to the CRTC, an opt-in regime for people receiving commercial electronic messages. And we'll get into what commercial electronic message means versus other types of messages. According to Industry Canada and in the bill, the general purpose of the bill is to encourage the growth of electronic commerce by ensuring confidence and trust in the online marketplace. So that, again, it's one of those interpretive clauses that they put into bills, which should be taken into account by the courts if there's any action involving CASL complaints. I mean, the courts are supposed to take into account that the purpose of the bill is supposed to be to encourage electronic commerce. As I mentioned, there are some key dates. July 1st, 2014, requirements regarding commercial electronic messages take effect. This will be of broad relevance to both registered charities and nonprofits. January 1st, 2015, there are requirements regarding computer programs and updates. Those will be of limited relevance. We won't really get into them, but if your organization uses apps or computer programs to deliver some of your activities, so if it's distance learning and you use computer programs, there will be requirements with regard to updates to those programs and whatnot. And then July 1st, 2017 is the end of the transition period, which we'll talk about later. And that's also when private rights of action, meaning class action lawsuits, become possible in cases where there are violations of the regulations. And on that matter, I mean, these are maximums. So don't panic too much when you see these numbers. But in terms of noncompliance, I mean, they've put in some pretty strict maximum penalties for noncompliance. Fines of up to $1 million for individuals who violate the rules and up to $10 million for corporations. And as well, the private right of action, class action lawsuits, up to $1 million in damages per individual that that has received unsolicited messages. There's also vicarious liability, they call it. So corporations are liable for the actions of their employees, and officers and directors are liable for wrongful acts committed by the corporation. So this is where it's key that that anyone who's involved in sending out your messaging, doing your communications, knows what they need to be thinking about, knows what they need to be doing, and the responsibility lies basically with the heads of the organizations, with your directors. Make sure your directors are aware of this as well, because there's going to be some risk management, some cost-benefit analysis that you may or may not want to go through with your directors, depending on your situation. And the bill gives the CRTC, who's going to be enforcing it, broad investigative powers. So they can get into your computers. They can go through your hard drives if there's a complaint about you. They can go through your hard drives to see what you've been doing, what you haven't been doing, and they can issue cease and desist orders, which would prevent you basically from sending any emails while they investigate. And again, these are all maximum consequences. So it's not as if you send out, an email by accident that someone gets, that suddenly you're going to be on the hook for $10 million or anything like that. These are maximums. And the CRTC has been pretty clear that A, they don't have the capacity to be watching everything that's going on, and B, that they much prefer, if something happens, to take a more educational approach in the first instance. The fines are really there for people that are consistently or blatantly violating the rules and not showing good faith that they're trying to comply. So there's this key concept in here of commercial electronic message, because that's really what's being regulated here. So there's a general prohibition. You cannot send a commercial electronic message to an electronic address. And this includes, like I said, texting, instant messaging, as well as emailing. So you can't send a commercial electronic message unless the receiver has consented to receive such messages and that the message itself contains certain mandatory information. Now, there are a number of exclusions and exemptions, which we'll go through, that are relevant to charities and nonprofits. But basically, as of July 1st, 2014, if you're not able to use one of these exclusions or exemptions, you won't be able to email people that you don't have an exemption for. And again, we'll talk a bit about that coming up. So what is a commercial electronic message? A message sent by electronic means that has as its purpose, or one of its purposes, to encourage participation in a commercial activity. And a commercial activity is any particular transaction, act, or conduct that is of a commercial character, whether or not the person who carries out does so in the expectation of profit. This was something we really tried to get them to back down on when they were putting the regulations together, that with or without expectation of profit, because that is the part that makes charities and nonprofits on the hook to be to have to adapt to this. It is a bit unfortunate that when they define commercial activity, they use the word commercial to define the word commercial, but that's the reality that we're dealing with. Now, examples of this include offers to purchase, sell, or lease goods or services, offers to provide a business, investment, or gaming opportunity, donation requests, and advertising or promoting these activities. So with regard to charities and nonprofits, chances are all of us engage in at least one of these activities that is considered a commercial electronic message. So again, do you send CEMs? I mean, emails seeking donations, technically that's a commercial electronic message. If you're selling tickets to an event or a lottery, that's a commercial message. Or if the message is promoting the event or lottery, that's a commercial message. There are some gray areas, which I mentioned, and some people will advise that you should think of these as commercial. Other people will say, no, these are areas that we're trying to get the officials to give us some guidance on and publish some guidance on. So if you're sending out messages trying to find volunteers or members, asking people to volunteer, asking people to join, that's a bit of a gray area. Newsletters on the surface should be okay, but there are people of the opinion that because the newsletter promotes the organization and the organization may be involved in some of these activities, that you should be careful with newsletters. So again, we're trying to get some clarification and some guidance on that, as well as emails just generally promoting the work of the organization, introducing yourself, what you do, even if you're not trying to sell something or get a donation. That's a bit of a gray area. And like I said, we're trying to get that guidance from the officials. Hopefully we'll have something in the next few days that we'll be able to report back, and we're going to be putting the pressure on them. They said when they issued the regulations that as questions emerged, they would publish guidance on their website, and so we're going to see if we can't hold them to that as questions have been emerging. So this idea of consent, after July 1st, commercial messages can only be sent with the explicit or implied consent of the recipient. And the onus of proving consent rests with the sender, so it needs to be tracked. So this is a key thing to be thinking about, is how, if someone questions you, you're going to establish that you've got express consent from that person to get any kind of email you want to send them, or to make sure that if they fall within one of the implied consent categories, which we'll be getting to, that you're able to track those, so that if anyone questions you, you've got a system in place so that you know on what basis you're emailing people. And the fun bit is, if you want to send messages to people seeking consent, that itself is a commercial message. So after July 1st, you can send messages seeking consent if you've got an implied consent, and we'll get to those. There are about 7 or 8 categories. If you don't have that implied consent from them, then after July 1st, you can't email them anything that falls within the definition of commercial, other than in certain circumstances. Now, explicit consent, this is the blanket one. Once you have this from somebody, they're fair game. You can send them anything you want. It never expires. You can get explicit consent from them electronically. You can get it orally. You can get it in writing. Now, the request has to clearly and simply, from the legislation, inform the recipient the purposes for which you will use their email address. Now, there's no specific set wording for how you word this, but essentially they'll use a reasonable person test. So the way you word the request, if you go this way, if a reasonable person would conclude that that includes you trying to sell them stuff later on, then that's the kind of wording you need to use. But again, there's no set wording or anything like that. As well, if you've already got consent from people, so when people sign up or subscribe to any newsletters you might have, if the wording of the consent that you're using right now would include these things, then that will carry on. You don't have to go back to those people that have already consented to receive all the different types of messages you might be sending. And again, not all of you will need to do the explicit consent route, depending on the type of messages you send and the types of relationships you have with those people. But if you are going to send out requests for explicit consent, you have to have your organization's identifying information, or if you're doing it on behalf of another organization, the information about them, your contact information, and you have to let them know that they can withdraw their consent anytime later on. So it lasts forever. Once you have explicit consent, it lasts forever unless they tell you to stop. Implied consent is something that, to a large extent, a lot of charities and a lot of nonprofits are going to be able to rely on, I think, for a lot of their communications. But again, this is something you'll need to look at who you're sending things to, the types of things you're sending out. In some cases, you may be able to just rely completely on implied consent going forward, depending on your lists and who's on them. In general, implied consent lasts for 2 years, and that gives you a window. If you want to convert that into explicit consent over that 2-year period, you can send people any types of email you want. And as well with implied consent, normally it's a 2-year thing, but for this transition period, if you've got implied consent from somebody right now, if they fall into one of those categories, you're good until July 1st, 2017. After that, it's only a 2-year rolling period for them. Now, some of the various categories, and I'll go sort of from narrowest to broadest here. Consent is implied if the recipient has put their email address, for example, a contact page on a website. They've made their email address public. They haven't put a statement on it that they don't want to receive unsolicited emails, and it's relevant to their business, their duties. So, for example, this is something that when I think of Imagine Canada as an umbrella organization, if we want to reach out to charities that aren't members of ours and promote membership with Imagine Canada, this is the kind of thing we'd use. If we get their contact information from their website, they're a charity, membership in Imagine Canada is relevant to them, we can email them about our membership program. So this is largely organization to organization. And as well, I mean, you could use this if you're selling a good or service or product that a private sector person might want to take advantage of as well. So it's not limited to charities talking to charities or nonprofits talking to nonprofits. This one is basically organization to organization. So they've made their information public. What you're emailing them about is relevant to them. Then that's implied consent. You can send them commercial messages. Another category here is, this is the sort of, they call it the business card consent. It's implied if the person you want to send it to has provided their information directly to you, for example, by providing a business card. They haven't said, don't email me, and it's relevant to their roles or duties. So again, it's very similar to the one where they publish their information online, but this is just somehow that they have handed you a business card or sent you or provided you with their contact information in that way. This one, again, this is the the exception to the implied consent in that in this case there's no time limit on the consent. So someone gives you a business card, says I'm interested in what you do, stay in touch, send me information. There's no time limit on that one. But you do need to document it. So if 3 years down the road they forget giving you their business card, if this is what you're using to as your justification for being able to email them, just make sure you're able to record when you put someone like this in your database that you're able to document it in case they forget about it and challenge you. The existing business relationship, this is one that will be of somewhat more relevance. So if within the previous 2 years the person you want to email has purchased or leased a product, goods, service, land from you, accepted a business investment or gaming opportunity that you've offered, so think lottery ticket sales, or entered into a written contract with you of some form, or if in the last 6 months they've made an inquiry about those things, then you have implied consent. So if someone has bought something from you, if someone has bought a lottery ticket from you, you've got implied consent. So from the date that transaction happens, you've got basically a 2-year period where you can send them any kind of email that you want to. And that 2-year period starts over with every transaction. So if someone buys a lottery ticket from you this year, and then they buy another lottery ticket next year, that 2 years starts over again every single time. So again, this will be one where, depending on the types of transactions, the types of relationships you have, this is something that could be quite relevant to a lot of you. Again, it comes down to tracking, to knowing, you know, Joe Smith bought a lottery ticket July 5th, 2014. We've got until July 5th, 2016 to either send them any kind of email we want, or if you want as well, get that express consent from them. So, so again, this one is of more relevance. The non-business relationship is the really key one, another really key one for charities and nonprofits. In the case of registered charities, if someone makes a donation or volunteers, you've got 2 years where essentially you can send them any kind of message you want. And again, this is transactional. So if they make a donation this year, you've got 2 years to either convert them into express consent, or 2 years where you can keep trying to get them to donate, sending messages or encouraging them to donate again. If they make another donation within those 2 years, then the 2 years starts over. So for people on your lists that are regular donors, you know, the people who donate every year, they donate every month, those ones you'll be able to roll over without really having to get their express consent, as long as they keep donating. And in the case of nonprofits, it's if someone has been a member of the organization within the previous 2 years, the same thing applies. And if they keep re-upping their membership, if they renew their membership every year, the consent goes forward as well. So the 2-year period could, you know, in some cases, if it's someone who's a regular donor or is a member year after year, that 2-year period could become permanent for a lot of those people. It's a matter of tracking and making sure that you don't let them fall outside of that. So again, why is the implied consent so important? Again, after July 1st, you'll only be able to send commercial messages for people where you have explicit consent or implied consent. So before July 1st, you can send to anybody. After July 1st, you have to have either already got their permission to send them anything you want, or they have to fall into one of these implied consent categories. So you'll be needing to think about how, from your lists, you can pull those people out and figure out who falls into which category. And again, during that implied consent period, you can send messages seeking explicit consent. And again, during this transition period, so the 2-year period for implied consent is extended until July 1st, 2017 for the first go-around. So if someone made a donate, if you're a charity and someone donated to you 6 months ago, you've got an implied consent period. Normally that would only last 2 years, but at the outset of this, it'll last until July 2017. After that, the 2-year limit applies. Now, every commercial electronic message has to have mandatory information in it, and this is regardless if someone has given you explicit consent to receive anything you want to send them, or if it's someone where there's implied consent. It doesn't matter what list they fall in. All the messages have to include certain information. It has to identify the sender and the organization, which seems a no-brainer. If you're trying to sell somebody tickets to something, you'd think you'd want them to know who you are. A means to contact you that has to be valid for at least 60 days. So if you have an email address that is the contact email, it has to be an email address that's good for a couple of months. So no using temporary email addresses. I think this is aimed at some of those people that send things out and then it's a dead email address to go back. It's a burner email address. And it also has to have a method to unsubscribe, and that if it's a link, then that link has to be valid for at least 60 days. Unsubscribe requests have to be honored within 10 days, and there can't be any cost to the individual to unsubscribe. And one thing that has come up, and again that we're trying to get clarification on from them, is depending on how sophisticated your email system is the issue of, can the unsubscribe be a message, please reply with unsubscribe in the subject heading rather than having a link or a button. And that is something that we're trying to get clarification from the officials on. So the way they've generally described it is that it has to be a link to an unsubscribe page or just a one-click button for unsubscribe. But we're trying to pin them down on whether, telling people reply with unsubscribe would be sufficient. Now, these are the bits. What we've talked about previously applies equally to charities and nonprofits. There's an extra exemption for registered charities, and that is a commercial message sent by a registered charity is completely exempt if the message has as its primary purpose raising funds for the charity. So essentially, if the only thing you're using email for in terms of trying to get people for generating money, if the only thing you're doing is fundraising, then you probably don't need to worry too much about any of this stuff. Again, there's a couple of gray areas here though. What constitutes primary purpose? So is that prominence of this will be, if you send out an email, let's say, saying, please donate to us. Oh, and by the way, we've also got this that you might want to buy. So we're trying to figure out if primary purpose is the placement of the donation solicitation, or if it's the amount of real estate it takes up in the email, or how they're going to be looking at that. And the other one is they use the phrase raising funds, but they didn't make reference to the CRA fundraising guidance. So we're trying to get clarification from them. Is the exemption limited to things that the CRA defines as fundraising, or is there scope for other activity to be included in there as well? So if you think of if you're delivering your charitable program, and there's a cost for materials or something like that. That wouldn't be CRA fundraising, but does the CRTC consider that raising funds? That's something that we want to get clarified, because the broader a definition of this we can get, the better it's going to be for charities. And then there are some other exemptions, of limited applicability, personal or family relationships. So someone who's a volunteer for you and wants to, they're doing a fun run or something like that. They send it out. They send an email out to their personal contact list. They can do that. Personal or family relationships, you don't have to have permission. If you're responding to a request or responding to an inquiry, then of course, you don't have to get permission in order to reply to them. Commercial messages sent within an organization, that would seem to be a no-brainer, but they do feel the need to specify that. Messages posted on social media, so someone subscribes to your Twitter feed, someone subscribes to your Facebook page, putting messages, come to our dinner, buy this, we've got this going on. That is fine. You might want to think twice, and again, we're going to try to get some clarification on this. Posting it on your Facebook timeline, that is fine. They've clicked like, they've subscribed to your feed. Whether that means you can send messages into their inboxes, that's still a little bit, that's still something that you'd want to think twice about until we get clarification. But putting stuff on your Facebook page, sending tweets, I mean, people have chosen to follow your tweets, but again, you might want to think twice about sending something directly to their Twitter inbox. And again, two-way voice communications, voicemails, faxes. So, welcome to the 1980s. You can fax people all you want. And as well, messages sent out of the country, sent to foreign jurisdictions, as long as you're obeying the laws in the recipient's country. So where you engage in international fundraising at all, these rules don't apply to your overseas people, but you've got to be following the rules in the country where they live if you're sending them messages. And that's probably not going to be too difficult, because these rules now that we have in Canada are going to be the strictest in the world. So if you're even close to matching the rules here, there's no other jurisdiction that you're going to get into trouble with. And then some limited exemptions. These, again, are some that where no consent is required. These are ones that allow you to send one message, and some of these will be important, especially I think the third-party referral. So if someone gives you the name and details of somebody who they think could benefit from the service you're offering, and you want to contact that person, and so let's say it's a course you're offering that someone's, yeah, I've got a buddy who'd be really interested in that course, here's his email address. You can send them a message about that person, but you should in that case say, can we get back in touch with you? You also have to tell them how you got their email address. So your friend Joe says, send an email to Harry about this course because I think Harry would be interested in that. You can send Harry that email, but you have to say in that email, your friend Joe said that we should email you about this. Others are, if the message delivers a product or service, then of course you don't need explicit consent for that. If it's confirming a transaction, so that would be, again, if it's if someone makes an electronic donation and you just want to send them a message confirming that it was received, you don't have to worry about permission for that. Or messages that provide factual information about someone's membership, a subscription they've got to something, And again, if they bought something from you, you want to send them messages about ongoing use of it. Or again, they felt the need to specify this. The HR department can send you messages about your benefit plans if you're fortunate enough to have those. The explicit consent, again, the CRTC has put out guidance on opt-in versus opt-out, and I think we're all familiar with how this has been done largely in the past. Someone gets your email address, the message comes to you, you scroll down to the small print, there's a box that says, yes, please keep sending me emails, and they've already checked the box, and if you don't want emails, you have to uncheck the box. The CRTC is saying that, no, you have to leave that box unchecked. The way you get explicit consent is you can have that box there, but the person has to check that box. So they have to be opting in. And again, once obtained, there's no expiry unless they withdraw their consent. If you're requesting consent, make sure that the way you word it covers the range of messages you might want to send. And keep in mind, too, that it can be granted in multiple ways. It can also be withdrawn in multiple ways. So if you're talking to somebody, if someone phones you up to make a donation or to ask about something, when you're getting their information, you can ask them over the phone, can we send you messages? Can we send you messages where we might be offering, tickets or informing you about events or lotteries or whatnot? You can get that consent over the phone, but again, if you do that, you've got to be able to track it. So, when they go into your database, if that's a field saying, consent obtained by phone by, this staff member on this date, something along those lines. You just need to be able to track it again, or in writing. So if someone is signing up for an event or for a program, on the sign-up sheet, you can have that part on the sign-up sheet where they can check the box when they give you their email address. Again, you can get that consent in writing, but again, you need to be able to track it. So whether that's scanning all those forms and keeping them on a hard drive somewhere or keeping them in a file cabinet somewhere, just so that if you're questioned about it later on, you're able to establish how it was obtained. So again, some general tips on getting ready. There's mandatory information, unsubscribed stuff. Make sure that if you've got a standard email template that you're using for commercial things, for sending out donation requests, for sending out lottery ticket information or whatever, make sure that it's got that information on it. Most of it is no-brainer, the things like who you are and how to contact you, but also the unsubscribe. And if you don't have an unsubscribe function and you're able to incorporate one, personally, I think it's a good idea to give people that option anyway. But it's going to be mandatory. Educate anyone in your organization who might be doing any of this stuff about what's going on, and that's volunteers as well as paid staff. Talk to and your board members so that everyone knows what's going on. Have some procedures for compliance. What are you gonna do to go through your lists and check who falls into what category? And again, this is if someone makes complaint about you, due diligence is a defense. If you can show, well, we've done X, Y, Z, we've really tried. That's going to serve you much better than if you've just ignored the rules and gone on your merry way as you have in the past. Again, establish a process to record consent. When people have given you explicit consent or withdrawn that, just have a way of being able to track that. If you use third parties to send your emails, get something from them requiring them to be CASL compliant. So if a third party is sending out your emails, get them to sign something assuring you that they are CASL compliant, because then if they aren't, then you've demonstrated that you have tried, and if they aren't, then the issue lies with them and probably not with you. And something that is out there is there are people starting to offer insurance for this. You know, I'm not saying buy insurance, but it's something to look into, especially if you're an organization that has significant assets. Probably the scariest thing about this, potentially scariest thing about this, is the class action lawsuit component, that if you're in violation, you can be sued, and the damages can be up to $1 million for every person who received an email. Now, if you're a small organization and you have no assets, there really becomes some cost benefits, some risk analysis where you need to bring your board into this. There's probably not a lot of class action lawyers that are going to go to the trouble and the time of putting together a lawsuit and finding plaintiffs and going through the court process if at the end of the day there are no assets for them to get their hands on. But if you're a large organization with a lot of assets, it's, again, something that might be worth thinking about is insurance. Talk to your IT people. Make sure that that they can track things, or that they can build in the database fields that you might need to track things. And again, too, if you think that you can rely on the implied consent going forward, that, you know, the only people you're sending messages to are your donors or your members or your volunteers, just make sure that you're able to record those things, and that you can document that each time there's a transaction that their expiry date, shall we say, gets updated. And so that's that. I mean, that was a pretty quick overview. There's a lot there. The unfortunate thing about not being in the room with you is that I can't see your faces, and I can't see whether your eyes have glazed over or whether I have confused you beyond all hope. I'm hoping I haven't, but we've also got a fair bit of time left here, just over an hour, for any questions that you might have, and I will do my best to answer those, keeping in mind that I am not a lawyer, and that we are working feverishly to try to get some clarification from the government officials on I've touched on some of the issues that we're working on that, and I'm sure others will come up that you'll mention. And I can tell you the status of those, but I'd be happy to answer, or try my best to answer, any questions you might have. Hello?
Question, Brian.
Go ahead.
Okay. Hi, Bill. Our charity has a lot of event fundraisers. So when someone signs up to be a participant or a volunteer for that event, is that implied consent? So are we allowed to send them emails that are specific to that event for that year?
Yeah. Someone who volunteers. Someone who volunteers, every time they volunteer, you get a 2-year window. That's implied consent when they volunteer. And again, someone who has made a purchase. So again, if the event is something that would fall within the CRA fundraising definition, for example. So if it's you know, if it's the fundraising dinner and you're issuing tax receipts, then chances are you don't need any consent. You can send a message about that to anybody because it's a fundraising event. And then someone who goes to that event, someone who buys a ticket, You would have the fact that they've made a donation, which is implied consent for 2 years, or the fact that they've purchased a good or service from you, which is again another implied consent. So in those cases, you'd have implied consent from pretty much everybody for a 2-year period.
Unmuted.
So follow up to that. So we're allowed to email them for that event for that year, but like the following year, are we still able to email them for other events? It's just that a 2-year window. It doesn't matter what the email is.
Yeah. In that 2-year window. So if someone makes a donation to you, you can email them over the following 2 years about anything you want to email them about.
Unmuted.
Okay, that's great to know. Thank you.
Hi, Donna. Your mic is unmuted.
Hey, Donna, your mic is unmuted.
Oh, thanks. Would you be able to give us an update on the different things that you're asking clarification on?
Yeah, like I said, I'm hoping, I'm just back and forth with the officials at industry and the CRTC, just trying to confirm a date for next week to sit down with them all. And my plan would be, as soon as I've got any clarification on any of these issues, and I've had this discussion with Simon, is I'll let him know and he can pass that word on to people as well. But my plan is to put something together to have up on the Imagine Canada website at that point. And as well, we would put some information out if you're members of Imagine Canada, if you've subscribed to our newsletter, Imagine Matters. Whenever we get clarification on anything, we'll be putting the word out through basically every means we have available.
Any other questions here?
Does that mean we can expect fewer local calls on our phones with their electronic?
I'm sorry, I could hear someone talking, but I couldn't make out anything they were saying.
They were just wondering if we could expect fewer calls on our telephone as well. I guess this is only email and electronic.
This is only email, and this is one of the arguments we made with the officials, because we were trying to get a complete exemption for charities and for public benefit nonprofits. And one of the arguments we used with them was, well, look, registered charities are exempt from the do not call list. So if someone really wants to be on the safe side, or if they can't afford to invest in the IT, you know what's going to happen? Instead of sending an email that you see in your inbox and spend half a second hitting delete on, they're going to start phoning people during dinner again. So I mean, it has no impact at all on the status quo in terms of telephoning. So if you're a registered charity, you know, you can phone, you're exempt from the do not call list, and you'll continue to be exempt from the do not call list. So any telephone campaigns that you're running are not affected by this. And again, the ironic thing for something that's supposed to be encouraging electronic communication and reducing disruptions for people, the ironic thing is that this could very well drive some organizations to just say, to heck with this, we're just going to use our do not call exemption and phone people again.
Hi, Bill. I just want to get your attention to the written questions. We do have a couple there.
Okay, I don't have that bit up on my screen right now. I have to figure out how to pull that up. Oh, here we go. Okay, what is the one here? What is the criteria for not-for-profits to be exempt? Not-for-profits, charities, registered charities have the exemption, the complete exemption for fundraising, as well as the implied consent and explicit consent. Not-for-profits, if they're not registered charities, don't get that exemption for fundraising. So if you're a not-for-profit, you'd have to be looking at the implied consent categories. So has somebody bought something from you? Are they members? Do you have an existing relationship with them, or have you got their explicit consent? So there's so they're not. No one is actually exempt. There are certain types of messages that are exempt, and we had tried to get a fundraising exemption for not-for-profits as well. But I think they had an issue with that because they couldn't see a way to differentiate between what we call public benefit not-for-profits and then other organizations that are set up as not-for-profits like industry associations or condo boards. So that's unfortunate. So like I said, as a not-for-profit, you know, you've got the various implied consent categories that you can rely on, but you don't have the fundraising exemption that registered charities got.
Unmuted.
Oh, I think it's actually in the written question. I just wanted to know if it was going to be available on PowerPoint. PowerPoint made available.
Can you hear us?
Hello?
Hello?
Sorry, we just had a question about whether it was going to be made available afterwards this presentation, but I think it was, yes?
Yeah, I've sent a copy to Simon, and there's going to be a recording, and I've sent a copy of my slides to Simon, so I'm sure you'd be able to get those from him. And feel free to contact me directly as well, you know, in future days if anything comes up.
Yeah, I'll send a copy of these slides in a PDF kind of form after the presentation, as well as the recording. At some point, it will be uploaded onto YouTube. And we
Okay, so I have a question here. We have lists of past learners that have signed up on our evaluation forms to receive our course listings as they are released. Would this be considered explicit consent or implied consent, and do we need to contact them in order to keep them on our lists? Again, if they've done course evaluations and there's been a specific thing, yes, please send me your course listings as they come. That would be 99% sure in my mind that would be explicit consent. You know, it's it's about the course listings. They've provided their information, and if they've checked off a box that says yes, please send me this, then that should suffice. Now, depending on how broadly or narrowly you worded that, now if they only consented to receive information about course listings, then that's all you can send them using that in terms of commercial messages. So, you know, you've got if that's the only thing you're worried about is being able to keep in touch with your former students, the people that have taken your courses, and keep them aware of upcoming courses, then that should be sufficient. You know, without seeing the form, without seeing how they've checked it off. But if it's clear from the form that they were asking to receive this information, then that should be sufficient. A question here about can we send out an email to anyone without consent about training workshops with a registration fee? We are a registered charity. That's one of those areas that that we're trying to pin them down on because, you know, in our mind, you know, when you're a charity set up to do particular things and you're offering those things, that, you know, to us is that raises funds for the organization, but because that wouldn't be within the CRA definition of fundraising, we need to get some clarification from them on is the charity's exemption purely related to things that fall within the CRA fundraising definition, or can we extend it to some of these other situations? And again, it's pretty clear that if it falls within the fundraising definition from CRA, it should be exempt. That's pretty clear. But something like a registration fee wouldn't necessarily fall within that CRA definition. So we really don't know at this point, and that's something that we want to pin them down on and get some guidance. And let people know as soon as possible.
Okay, we're going to take another voice question here.
Unmuted.
On our website, participants can send donation requests as well as, hey, you should join my team for an event or thank people for their donations. And so it's sent through our website, but it's actually sent by their email address. So I'm just wondering if we're held responsible for those messages that are sent out because the link is to their fundraising page or to the registration link. So even if it's not branded or anything and it shows that it's coming from that participant's email address, are we still held responsible because it has that link to our website?
I'm sorry, I didn't quite follow that one.
So
Unmuted.
When participants sign up for an event online, they go to like a participant, like a dashboard, so they can see who donated, as well as how much they've raised, etc. So through that function, they can send emails. It says it's from their email address, but it's through kind of our tool from our website that they can do this functionality. Are we held responsible for those emails being sent to those people because there's a hyperlink to the website?
Oh, I see. Yeah. So, okay, so that would be like when I do the Terry Fox run and I use the online platform to email all my buddies. That actually is, I haven't had that question posed yet, and I honestly, that's something I'll need to ask them. I honestly don't know, because if they were sending the email out directly to their friends and contacts, it wouldn't be an issue because there's that personal exemption. Whether the fact that it's coming through your technology, even though it shows as coming from their email address, that's something I'd have to check on.
Okay, I think we can go back to the written question here.
Okay, yep. I was sorry, I was just scribbling myself a note to check on that one. So here we go. I have a couple of questions. First off, my organization sends out an e-news that qualifies as a commercial message. In order for people to enroll, they either have to ask us to enroll or click a button to sign up for our e-news, the only thing that the email list is used for. Regardless of how they sign up, they get an initial email that requires them to click a link to confirm their subscription. Would this be sufficient for explicit consent, or do we need to retroactively obtain it again? Secondly, if we do a Facebook event and send invites to the event, is this a CEM? The first one, well, I guess if they're actually having to physically subscribe to something, then it's probably not a worry, because the aim of the bill is unsolicited messages. So if someone has subscribed to receive a newsletter, then that shouldn't be a worry, because it's all about things that people haven't asked for. So if they've asked for something, then you should be safe. If we do a Facebook event and send invites to the event, is this a CEM? That is a good question, and that is something I will check on and see how the officials propose to deal with a situation like that, and it's something that we can report back on. Again, it's not a question that I've had come up yet, so thank you for that.
Unmuted.
Hi, just a quick clarification. So for existing relationships, you talk about people who purchased something, they have a contract with you, they're a volunteer, they're a donor, they've participated at one of your events. But what about other organizations that send you referrals? Like as a youth serving agency, other organizations or businesses, social workers, that kind of something, they can say, we have a kit for you here, so can we contact them to say we're now ready for more kits if you have them?
Oh yeah, because if so contacting the referring agency, you mean? Yeah.
Yes.
Yeah, because that would be a message about your business and their business. So you know, it's that's one of those, you know, the information publicly available, and it's about your business. It's that organization to organization. So that shouldn't be a problem at all.
Unmuted.
Oh, I just wanted to clarify. So volunteers, participants, and donors, that's all implied consent, and we can email them for that 2-year period for like whatever email. It doesn't have to be in relation. Okay.
Yeah, and like I said, it's that 2 years starts each time they make a donation or each time they volunteer for something. So if you've got someone who makes, you know, a donation, if they've got a monthly direct debit as their donation form, basically that 2 years is starting again every month.
Unmuted.
What if you have volunteers who are long-term volunteers? Like I have volunteers who've been for organization 5 or 6 years, and they just have been continuous. So do I have implied consent with them, or do I need to, at the start of every year, get permission from them again?
Well, I think it's if they're turning out and doing something every year, then every time they turn out and do something, then the 2 years starts over. But if it's a pool of people, and let's say someone is in your pool of volunteers and the last time they actually were able to do something was 3 or 4 years ago, then that probably wouldn't suffice. So it's those sort of cold contacts like that, if you want to call them that. So if you're looking at your volunteers and there are people that, you know, used to volunteer and they haven't for whatever reason done so for a while, or if it's people that donated 4 or 5 years ago, and so that implied consent wouldn't apply anymore with them, those are the ones that you'd really want to be getting to before July 1st if you can, to try to get their permission. But if it's people that are, you know, your regular volunteers and they're coming out, you know, once a year or once every 6 months or whatever, each time they do something.
Okay, we're back. Bill, are you still there?
I am here, yeah.
Okay, yeah, we do have the one question here by Pat.
Yeah, being a follower or like, our understanding is, again, there's now there is reference in the legislation that, you know, with social media platforms that, you know, if you're that, you know, people accept certain things when they sign up for social media, but there's also the fact that, you know, like I mentioned before, if you've got your Twitter account, you can use, you know, you can tweet anything you want. You can put anything you want on your Facebook page. People that have chosen to follow that, you know, that you can't control that they've chosen to follow that. You put your information up. If they don't like getting your updates, they can unfollow you. They can unlike you. The part that we're not completely sure about is what that means in terms of if you want to direct message them using, so if it's someone on Facebook, you know, you put up an event, that's fine. They see you in their news feed. If you wanted to inbox everyone who's liked your Facebook page, that part we're not sure about. So, you know, posting your updates to your timeline, that is one thing, but whether you can inbox them based on the fact that they've liked you, that is something that we're trying to get some guidance on, if that helps.
afterwards.
Unmuted.
Hey, I have a question about the about social media platforms, and understanding that everyone's a little bit different, but oftentimes they have some things in common. I think of Facebook as kind of one of the prime examples, where you have the ability to invite a lot of people to like your page as it presently stands, as it's presently built, who may not already be connected to you. They might be friends of friends, and then Facebook just kind of provides you the names. You could say, invite to like your page. Mm-hmm. And would that be okay on the one hand? The other question I would have is, would that be any different than if we were to use Facebook's built-in advertising regime to advertise our own page to people, which then Facebook looks at people's profiles, information that they've already put out there. We might be looking through certain categories, like that they're interested in the nonprofit, or interested in volunteering, or interested in community, and we advertise our page based on those criteria to people, which to them might seem unsolicited, but to us, we're just kind of using Facebook's existing platform. And then I guess the third question I have is, to what degree does Facebook then take on the responsibility of managing that? Because in a way, they're just kind of brokering that relationship between us, but it's their platform. People opted into it. And so is it more like an umbrella for Facebook to be responsible, less us?
Yeah, there is a reference in the legislation to social media platforms, and basically where if you're using social media in a way that people have consented to have it used when they signed up, and scrolled through the 55-page terms of reference and didn't read any of it and clicked yes, continue, then you should be okay. What I might ask you to do, if my email address is on the front of the slides that Simon's got, if you wanted to send me an email, because those are really specific questions that I haven't had come up yet, a couple of those, and that's something I would definitely want to put to the officials and get their feedback on it, because in terms of like the ins and outs of Facebook's privacy policies and the legal position that people put themselves in when they sign up for a Facebook account, I'm not completely on firm ground on those. So that would be something, if you wanted to drop me an email, I'd be happy to check into that for you and get back to you.
Unmuted.
Is the consent linked to the email address of the person? Because some of our constituents or donors, whatever you call it, they have the same email address. So a husband and wife might have the same email. So if they unsubscribe from something on our website, that will be linked to the email address. So is that a concern of ours then? So if they unsubscribe one way, then the husband unsubscribes, but wife doesn't, but they both have the same email address. Is that?
Yeah. I mean, if it's one email address, basically, if that email address unsubscribes, then you have to go on the assumption that, I mean, you can't assume that someone else is using that email address who wants to get your stuff. If you get an unsubscribe from that address, then that's it.
Unmuted.
One of your slides you had investigate insurance options. Can you just reiterate why we would want to buy insurance?
Well, that would be again if you really want to be on the safe side, potentially. And I think again this is for people that are worried about the class action lawsuits and the liability associated with those. Again, I think that's, if you're a larger organization and you've got assets that people might want to go after, then it's just something to think about, because my understanding is that there are some insurers that have started to put together packages, and it's not just for charities and nonprofits. We have to remember that this entire thing applies to the entire private sector as well, except it's probably hitting them even harder because they don't have as many of the implied consent provisions or exemptions to rely on that that we do in our sector. So there are companies out there, my understanding is, that have started to put together liability insurance for people, for CASL violations, that if you did get sued, you'd have insurance. Again, it's just something to keep in the back of your mind. I'm not saying do it or don't do it, but just be aware that some of this is out there, and it's something that, depending on your situation, you might want to investigate or look into doing.
Hi, Bill. There was a question that I posted there. It came from someone who was unable to attend. So wondering if you could look at that and address that, maybe.
Oh, is this the one about the newsletters? Our membership cycle begins in September, so we will be seeking active formal consent as part of the registration re-registration process. That said, we're trying to avoid providing recipients of our member newsletter the option of opting out if we don't have to. My read of the legislation is we do not. If it is internal communications among members, we consider our newsletter to be that, but it also includes advertisements and deal offerings, which presumably could lead to a transaction. That is where the gray area lies for us, and is what I am trying to clarify. If it's got advertisements and deal offerings, then they would consider it, the regulators would consider that a commercial message. And even where you've got the consent, whether it's implied or explicit consent, if it's a commercial message, it's got to have the unsubscribe option. So unfortunately, you do have to give them that option of opting out if the newsletter has, is advertising deals for people, even if it's not a commercial activity that involves you, if it's promoting commercial activity. So if it's got advertisements, if it's got people offering deals, that would put it probably into the realm of a commercial message, and any commercial message has to have an unsubscribe mechanism.
Are there any other questions out there?
Unmuted.
So just to clarify again, we have evaluation forms at the end of a session, and then there's a checkbox that says if you want a newsletter, check here. So they've given us consents. And then those pieces of paper, do we need to keep those indefinitely somehow?
Yeah, I guess, if you're relying on that for the explicit consent, do you have to keep them in paper form? You could, if you wanted to scan them, if you wanted to do whatever, but if one of those people ever complained that you're sending them emails without permission, and you'd need to be able to establish that they had given you permission. So whether it's keeping the paper copies somewhere, whether it's scanning it, whether it's microfilming it, it's whatever works best. But you would want to be able to track those.
Unmuted.
So then for people that we have, like, prior to all this, do we need to go back to them and get consent, or going forward? How does that work?
I guess it all depends on, again, what type of message you're sending them and how the consent was worded. So, for example, if it just said, yes, please send me your newsletter, the CRTC might say that that's not specific enough. They've agreed to receive a newsletter. They haven't agreed to receive messages that might be trying to sell them something. So again, if you've said, if it's please send me your newsletter and offers for future events, then you'd be on safer ground with that. So depending on the wording of what they've checked before, you may or may not have to go back to them. If, like I said, they have what they call the reasonable person test. So if a reasonable person would look at what they had previously signed and said, well, of course they consented to receive, you know, dinner ticket emails or something like that, then you're probably okay. But if a reasonable person would look at it and say, well, no, they signed up for a newsletter and this isn't a newsletter, then you'd want to think about going back out to them.
Unmuted.
In regard to volunteers, going on similar things we were just saying, if when they apply to be a volunteer, if they've given you their email address, then can that be taken that they have given consent to receive any kind of messages from us?
Yeah, if they volunteer, then that's implied consent for any kind of message you want to send them. And again, that's one of those that rolls over every 2 years. Now, what you could do is when they sign up as a volunteer, if they're filling out the form they're filling out where they're providing their email address and whatnot, if you wanted to add a line to that form saying, please check here so that we can continue to send you information about X, Y, Z, then that would become explicit consent if they check that box. And then you wouldn't have to worry about the 2-year limitation with them. I know this whole thing is a lot to wrap our heads around. I've been living with this file for 1.5 years, and I still haven't got my head completely wrapped around things. So, you know, again, hopefully we've given a bit of an overview. Hopefully the slides will, if you go back and refer to them, will tweak some things in your mind. And as well, like I said, there's the actual government website, the fightspam.gc.ca, where they've got copies of the bill, copies of the regulations. Like I said, they do have some FAQs on there. Not enough. That's something that, like I said, we're going to try to get them to beef up. But there's also contact information there for the people that are responsible for this. So, you know, going forward, feel free to contact me. You know, drop me an email, give me a call. My info's in the slides. If there's anything we can do to help out, to try to answer any questions, contact the officials. And to be quite frank, I mean, if you're really having trouble wrapping your head around something, or it's just really placing a burden on your organization, every party in the House of Commons voted in favor of this, and MPs' offices are there to help out with things like this too. So if you're finding that you can't get answers, that you know, we're unable to provide you an answer, or the officials aren't getting back to you if you try contacting them, get in touch with your MP's offices to try to get them to help you out getting some answers, because you know, A, that's what they're there for, but B, you know, if people are going to be having serious problems arising from this, you know, the MPs are the ones who voted for this, and they need to know what's going on and the impact that it's having on organizations in their constituencies.
Are there any more questions out there? Well, if there's nothing left out there, I guess we could end the webinar early. Bill, I just want to thank you for presenting this webinar on the anti-spam legislation that's coming up. We really appreciate it.
Thanks for setting this up, Simon. It's really important for us to be able to get information to people, and give them our perspective on things and let them know what's going on to the best of our ability. And we really appreciate your taking this on and putting it together. It's really helpful.
So again, just a reminder to all the participants here, I will be sending out the PowerPoints to everyone. You feel free to share it with your network organizations. As well, I will be at some point posting the video onto our YouTube. And we will also send that link out as well. Feel free to share that. And also, in case you don't have Bill's email, I will include Bill's email with his phone number, so you can feel free to contact him for clarifications on other issues that you have here or there, and maybe questions that maybe weren't answered yet because of the gray areas that are still existing. Bill, is there anything else?
Not at the moment. Not that I can think of. No. Like I said, as soon as we get some clarification from the officials on various things, we'll be putting updates out through all of the channels we've got available to us, and including, I made a commitment to Simon that as soon as we hear anything, we'll provide that information to Volunteer Alberta as well, so that that they can put it out through their networks as well. So.
All right. Well, I guess this wraps it up. I just want to thank everyone for attending this webinar. Thank you to Bill again from Imagine Canada for presenting this. And we hope it was informative. We hope that this information will help your organizations stay safe and understand the legislation that is coming up and the steps you need to take in order to be compliant with it.